Good morning, Mr. Wardell.
Good morning, my lords. I appear with William Hooper for the Appellant BSV Claims Ltd, the claimant class representative. My learned friends Mr. Kenley KC and Mr. Popjoy KC appear for the respondent Binance D6. Binance is one of the crypto exchanges we allege unlawfully...
Mr. Wardell, you've got a bit of competition from out there this morning, so
Okay.
Voices up, please.
I'm sorry, my lord, is that better?
Yes, yes.
Binance is one of the crypto exchanges we allege unlawfully colluded with the other defendants, contrary to Section 101 of the Treaty of the Functioning of the European Union, Section 2 of the Competition Act. Binance applied to strike out part of the claim and or for summary judgment on two grounds. First, it sought to strike out or obtain reverse summary judgment in respect of subclass B's claim for damages referable to the foregone growth effect, i.e. the loss referable to how the crypto held by members of the class, being the Bitcoin Satoshi Vision, or BSV for short, would have grown in value but for the defendant's wrongdoing. Secondly, it sought to strike out, obtain reverse summary judgment on subclass B's alternative claim for loss of a chance. That was successful, and that is the subject of ground 2 of this appeal.
Now, can I just, before you go on, tell you that I'm, at least for myself, interested in the seemingly unsatisfactory process by which you applied to the registrar to ask, does the judgment, the decision of the CAT, mean that we can't argue these points at trial?
Yes.
And the registrar wrote to you and said, of course it does. It seems that looks from the judgment as if they really meant it. And so obviously you can't argue it at trial. But in the courts, it is orders that are appealed. I believe my Lord, Lord Justice Snowden, have had previous cases where this has been argued. And I know that the president of the CAT is fairly, the former president of the CAT, or the Justice Marcus Smith, was very keen on saying that they didn't need orders in the CAT. The decision spoke for itself. The problem with the decision speaking for itself is that you've had to write to the registrar and said, what does this decision mean?
Yes.
And there is no order, and it's really, to my mind, very unsatisfactory to appeal the whole of a 60, 70, 80 paragraph decision. So I would like some argument as to why, under the CAT rules, there is no need for an order, and whether it would be better if there were an order in the CAT as in the courts, and what effect that would have on other aspects of the tribunal system, this tribunal and others, and whether we should say anything about that, because for my part I find it rather unsatisfactory that this is the way this appeal appears in this court. And it's appeared in at least 3 cases that I've been involved in the last couple of years, and I had a word with the Chancellor, and he says even more cases have had the same problem. So at the very least, if I'm thinking ahead, I would like to see the CAT have a passage in its decisions at the end which say disposition, and then clarify precisely what is being decided and declared by the order, in a case of this kind, but in a case maybe of other kinds too. So I just give you notice of that, because it's something that I would like you to be able to say what you want to say about, all of you, because it may appear in my judgment.
Thank you for the indication. I have to say I did not anticipate having to deal with this point, so can I proceed?
You can do it over the short adjournment and come back to it. As regards the substance, Mr. Wardell, we have read a fair bit about this. We are concerned that we don't fully understand what your case is as to loss on the pleadings, and we think you might like to show us that.
Right.
And what we're concerned about is we understand the three categories, but we don't really understand why the third category has completely lost access to their crypto asset, and the second category hasn't, and what is the right that you have. So you may know that I chair the UK Jurisdiction Task Force, and we've expressed views about whether a crypto asset is property or not.
Yes.
But we are confused by the relationship between the holders of this particular crypto asset and the exchange, and why the delisting on the exchange has left people unable to sell, say, privately, the asset at all, and in some cases has left people without access, category C, to the asset, and what your case is, because it seems to me at first instance, speaking only from my first sight, that this all may be rather complicated and may require quite a lot of argument in due course as to precisely what you've lost and why,
Yes.
which is by no means necessarily simple. But we need to know what your case is and precisely how it's put and what the right is that you allege you've lost.
That's helpful too. So far as the categories are concerned, you will see that the three categories, subclass A, are people who comprises 155,000 people who all managed to sell their BSV after the delisting event. Subclass.
Well, I can understand that you can sell it immediately.
Yes.
Then it's delisted from the exchange. But why is this crypto asset not in the wallet of the holder, which enables them to go to another exchange? Or were there no exchanges that listed it? Were they all in the deal?
No, there were other exchanges that continued to list it.
Yep.
So
why couldn't you go to them and sell it there?
you could.
Right.
The damages claimed by the people in subclass B relate to the lost, or what Mr. Noble calls the foregone growth effect. We're saying that because of the delisting, there has been damage to BSV which continues, and essentially, if it hadn't been for the delisting, BSV would have moved from being a contender currency to a major currency or first tier currency like Bitcoin or Bitcoin Cash. And essentially what Mr. Noble is saying, there is an ongoing permanent loss of value, which is what he says those in subclass B should be able to recover.
But if you could retrieve Bitcoin from the exchange, I mean, as I understand it, you would have an account with the exchange whilst the Bitcoin was listed on the exchange, and you would have a certain credit in your account with the exchange.
Yes.
The exchange then, quote, delists. You can, as my lord's just put to you, you could ask for delivery to you of Bitcoin representing the balance on your account.
Yes.
And then take it to another exchange and sign up with another exchange, and your Bitcoin would be then on the other exchange.
Yes, but by then you've lost the value. That's, I mean,
Well, that could happen virtually instantaneously. Yeah?
Well, Mr. Noble's view is that as soon as the delisting event occurred, there was an immediate loss of value, and that's what he says those in category A should be able to recover. Because when they sold their Bitcoin, their BSV, they had obtained less for it than would otherwise have been the case but for the delisting. But he approaches damages in respect of subclass B in a different way. He approaches it on the basis of the foregone growth. Now, he may be...
On the basis of what you said, is there a category C?
Yeah, I was just about to ask
Yes,
that.
because category C are those people. There are two parts of category C. First of all, is those who had their Bitcoin on Kraken, and they say that sorry, we'll rephrase that. Their Bitcoin was converted into Bitcoin, and so their loss is again
Their
different.
BSV was converted to Bitcoin.
Exactly. So their claim is for the immediate and persistent effect, is how Mr. Noble puts it, plus a conversion fee. A subclass C holders on Binance, they claim the foregone growth effect, similar to subclass B, except that there is no credit for any residual value of the BSV in their hand.
Where is Class C defined?
You'll find it, well, the easiest place to find it is in our skeleton argument of paragraph 7, and I can get you the reference to Mr. Noble's.
Okay, well, I think I've got your skeleton argument.
It's core bundle, tab 7, page 87.
So, why users of Binance or Kraken who held BSV coins in their accounts on the 11th of April and lost access to their coins as a result of delisting? Why do you lose access to your coins as a result of delisting?
Well, Kraken converted them to Bitcoin. So, I'm afraid you probably know more about the mechanics than I do, but the case is that those who were on Kraken had their BSV converted, and I don't think there's any dispute about that between the parties. If you go on to paragraph 831,
So are you saying that the conversion rate was affected adversely or something like that?
exactly. But
Why is there such a long gap between the 11th of April 2019 and the 29th of July 2022?
Well, 29th July 2022 is when proceedings were issued. That's why that date is taken, because people in subclass B never sold their BSV. So what Mr. Noble's report, which is also...
But you couldn't sell your BSV for those whole 2.5 years on Binance or Kraken, could you?
No.
No. But they managed to sell them elsewhere.
Well, subclass A managed to sell them elsewhere. Subclass B didn't sell.
And some of those, that would have been a deliberate choice if they knew about it.
Yes.
And others who, as the cat said, didn't know about it, might have different considerations applying to them.
Exactly. You have it.
But in relation to subclass C, so you're saying that in breach of contract, is this right, with the exchange converted BSV into Bitcoin?
But we're not running, it's not being run as a contract claim, it's being run as a breach of statutory duty tort claim.
No, I understand. Okay, so, but I'm just trying to understand what you say happened contractually. So, are you saying that they were or weren't entitled, as a matter of contract, to exchange your BSV for Bitcoin?
I haven't looked at the contractual side of it. I'm thinking aloud. I'd say that a forcible conversion of your BSV into Bitcoin would be a breach of contract.
Okay, but let's assume one way or another they change BSV into Bitcoin. Why does that result in the loss of the entirety of the value of the BSV, which is what you say in paragraph 8.3.1 of your skeleton? I don't quite follow. I mean, you've lost BSV, but they've been replaced by Bitcoin.
Yes, but
But you could then use the Bitcoin to buy BSV on another
we're only
exchange.
claiming the difference between the value we would have achieved on the sale and what we actually achieved. We're not saying complete loss of value.
Well, I thought that's what you were saying.
No. And if our skeleton gives that impression, it's wrong. The immediate persistent effect is effectively the diminution in value caused by the collusion.
Okay, so 8.3.1, can you just unscramble that for me?
It says you claim by reference to the foregone growth, but you're saying that's wrong, are you?
I'm sorry, I was looking at, I was answering the question I thought about subclass A, of those who actually sold.
Sorry, I was asking you about C, in fact, sorry.
I apologise. So C, Mr. Noble with C is to separate it out, those on Kraken and those on Binance. Those on Kraken he's treated effectively as being the same as subclass A, with a few minor differences, but subclass C, Binance, he treats them as being, as having lost the growth that would otherwise have obtained by BSV turning into a major currency.
I mean, at the moment, I find these phrases.
I do apologise.
I find these phrases used apparently by the expert incredibly confusing. The words immediate and persistent effect don't have any sort of previous meaning. They're just something. They're just words, really, and unhelpful. And the words foregone growth effect is equally unhelpful. We need to talk in legal terms about what your claim is and how it is calculated. And I find just sort of reading across from an expert report about something quite different, apparently, to this claim makes it unhelpful. Where's your pleading?
The pleading is in supplemental bundle, and it starts at, you find it in tab 3, which starts at page 90, and it goes all the way through to page 150.
Right, now where is the pleading of loss? Relief sought?
It's earlier than that.
Infringement, breach, liability?
Bear with me a second. So if you go to page 93, paragraph 8,
Yeah.
the infringement caused the price of BSV to fall in the immediate aftermath. And then there's a quote from Mr. Noble's report. And then 5 lines in, the infringement which had both immediate and persistent long-term effects for BSV holders, including the foregone growth effect, meaning the lost opportunity of BSV developing into a top-tier cryptocurrency and the expropriation of coins from users of Binance.
Just pause there. Expropriation of coins, that, are you saying that they were taken without compensation?
Well, with Kraken, they were taken and converted.
But expropriation normally means taking without anything being given in return, doesn't it?
Yes.
So are you saying, which is consistent with what I was asking about subclass C, paragraph 8.3.1, I was trying to ask you, are you saying that some people just lost their BSV completely?
Yes. Those
With
on
nothing in return? Nothing.
No. In terms of Binance, they have lost access to their coins.
How?
Well,
I just don't understand how you can lose access to your coins because the exchange delists them. You have a private key, don't you?
you do.
Yeah. So why can't you go to another exchange and sell them?
They're not my. I mean, it's not my pleading. It's not my categories of loss. I'm not
Well,
trying
it's
to.
your client's. It is actually your
Hang on.
client's pleading, isn't it?
Yeah.
It is.
Yes. I'm not trying to be unhelpful, but
No. Well, I mean,
you
let
asked
me just say it is unbelievably unhelpful to plead by reference to an expert's report. Experts' reports are evidence, and pleadings are legal claims that are stated on the facts. They plead the facts and the legal claims made. This is really not a helpful way of doing it. You know, we need to know what loss so that we can examine the legal decision made by the tribunal. We need to know what claims you make for these losses in category B and why legally they're recoverable.
So we set out the table in paragraph 9 of our appeals skeleton, which you'll find at page 88 of the core bundle. And there we set out the claims.
But that's just figures.
That's just the figures, yes. Well, the way the claim has been pleaded and the way it's been put is by reference to Mr. Noble's report.
We
Adopted.
better look at Mr. Noble's report then to find out what the legal claim is. It's an unusual place to look for it.
So, Mr. Noble's report, if you go to the supplemental bundle, on page 148,
Yeah.
what's wrong with
Annex
it? 48, not 148, I apologise.
48.
Yes.
Yeah.
And he deals there with the users of Binance in subclass C, which is the questions I've been asked about in relation to 831, my skeleton. For users of Binance, they've suffered a first harm similar to that of members of subclass B, i.e. estimated damages on the foregoing growth effect. And they've
That's
also,
not a legal claim.
and then he says the users of Binance have lost the complete access to their coins. That's my understanding of the facts, and I'm afraid I can't answer your question as to why people in those.
I mean, there are two possibilities, Mr. Warder. The one possibility is that your property in BSV was damaged by the breach of statutory duty of the defendants and therefore was reduced in value by that tort.
Yes.
From a value of 100 to a value of 50, in which case you might claim 50 on that basis, right?
Yes.
The other alternative is that this was a fungible that was equivalent to any other market listed asset, which you lost in some way as a result of the tort, and you should have gone onto the market to buy equivalent. So if it had been coal, you would have had to go on the market and get coal because coal was readily available and it had a market price, and you've lost the difference between the market price and the actual price.
Yes.
Now, which is it?
Well,
What do
The first alternative is subclass A. The second alternative you just postulated is what CAT decided was the position on a summary basis. But what Mr. Noble, the third possibility for Mr. Noble is that those, not only was there an immediate loss, damage to the value of the holding, but BSV as an entity has lost the chance of becoming a major currency. And he calculates the damage on an ongoing basis. It's what he calls the foregone growth effect. He says if it hadn't been for the tort, BSV would have over time become a major cryptocurrency like Bitcoin or Bitcoin Cash, and because of that, the holders of BSV in subclass B, would now have a very valuable claim. That's how he puts it.
But the very worst thing that could happen to you, not quite sure how it could happen, but the very worst thing that could happen to you is that you completely lose all access to your asset. So you had something which, as my lord says, was worth 100, and now you've got 0.
Yes.
So, and the figure of 100 is a figure which represents the market's view of the future prospects of the asset. So it has, as it were, what you call the foregone opportunity already built in. In those circumstances, how can you possibly ever have damages of more than 100?
Well, I see the point.
Well, you see, if you had a table, right, and it was a valuable antique table worth today 100, and somebody came and destroyed it with an axe, right, you would claim against them the value of the table 100. You would not claim and not be entitled to 200 because valuable antique tables were going to be worth more in the future, possibly. Would you?
Yes. No, you wouldn't. I see the point. I'm not sure I've got an answer at the moment.
Right.
So,
you know, because you destroyed, I mean, the tort took place at a particular time, and you should have gone out. I mean, even if it's a valuable antique table, actually, you're compensated for the value of the antique table by the value that you lost. I mean...
And the market, you would tell me...
I mean, are there authorities that say if the valuable antique table has doubled in value between now and the trial? I suppose there are out there that say that you can...
If that value of the antique table increases between the date of the tort and trial, yes, that would be recoverable.
Well, would it?
Yes. We've got authority about that, which we can take you to.
What is the authority?
I can't remember the name, but
I'd like to know, because I think that in itself is quite complicated, but it is, I can see that it might be possible. But then might call into question whether you should reasonably have mitigated your loss by buying another table. If there were one.
If it was possible to buy another one.
Yeah.
See, I understood perhaps this foregone growth effect, as I understood it, was everybody who held BSV, in fact, on other exchanges, would be adversely affected by the fact that these exchanges, who are the defendants, delisted it, damaged its reputation as a cryptocurrency.
Yes.
And I understood that this foregone growth effect is, it's said to be a reflection of the fact that all BSVs, wherever they might be traded, whichever exchanges they might be held on, were adversely affected. Their reputation and value was affected by the fact that these particular exchanges delisted them.
That's the way it's put.
And that's which you say is recoverable, and that wouldn't necessarily be quite the same as the points that have just been put to you, because that's a type of damage which reflected in the sort of axe to the table, if I can put it that way, example, I think. I mean, that's how I understand. I still don't understand quite how Category C arises, but unless it's just effectively a failure to deliver coins.
I don't
BSV.
Sorry, I didn't mean to cut across.
I understood that your foregone growth was sort of something akin to reputational damage to BSV as a currency, done by the fact of delisting, which in fact would affect everybody who holds BSV in the market.
The analogy would be not just the damage to the one table, but if all antiques of a certain class lost value because of a particular tort.
You say this is a particular feature of cryptocurrencies, that in effect their value is just reputation in some
Yes,
way.
value is what the market deems it to be, and it's very that explains its volatility.
I mean, your best point, perhaps, is that this is a unique asset, like the table, and you will show that at trial, that it's not actually equivalent to Bitcoin, not the same as Bitcoin.
Exactly.
It's not the same as anything. It is a unique crypto asset. Crypto assets have particular attraction to particularly different people. And there are quite a few of them, stable coins and all sorts of things that you can choose to invest in or to buy. And the value of this has been damaged by delisting on well-known exchanges. Its reputation has been damaged, and there could be evidence, I imagine, about how the reputation of crypto assets affects their value. And you particularly wanted, the 75,000, particularly wanted to invest in this and keep this, and expected it to become incredibly valuable in the future. And then the question is, can that be struck out without a trial on the basis of evidence that was about something else?
Yes.
Without the court concluding that the reasonable mitigation of this particular wrong was to go and buy something else.
Yes. That you've encapsulated our appeal of ground one.
That's it. Well, it's ground two as well, isn't it? Because it's
Yes.
the same thing.
Yeah, exactly.
Does Mr. Noble say anywhere in his report anything equivalent to that before these events occurred, the value of this cryptocurrency was 100 and afterwards it was 50 or
Yes, he does.
Yes, he
0?
does.
Can you just give us the reference to that?
Yes,
please?
of course.
That is actually to be found in the pleading at paragraph 9.
But Mr. Noble, that is taken from Mr. Noble.
It is taken from Mr. Noble, but it's quite an encapsulation, because what he says is it was worth 50 something, 55 on the 11th of April and 39 a week later. Paragraph 8, line
Oh yes,
4 and 5.
yes, thank you.
But I mean, what I don't understand is, let's assume all your claimants sold after the first week. Do you accept that the claim is only for £16?
Yes.
You do? Yeah.
For those who sold.
For
yes.
those who sold. So why is it billions for those who didn't? Sorry about the billions, but I mean, it is.
Well,
we are.
It's a large figure.
Yeah, I don't
Potentially.
understand why it isn't. I mean, surely they could have sold, and I mean, it's quite an attractive argument to say, well, this may not be equivalent to a fiat currency.
Which we say it's not.
No, it's not a fiat currency, but it's also it is equivalent to a derivative, isn't it, of some kind? I mean, in derivative trading, for example, you wouldn't be saying this is a unique derivative, that has been damaged by this wrong. Therefore, I can't buy other derivatives and continue to trade on the market and make money. So why should you get more than £16?
Those who hung on to BSV, one doesn't know what the evidence will be, but BSV is regarded by its followers as being the closest to the original white paper. And there is an ideological element as to why people want to buy BSV as compared with another cryptocurrency. So we say all of this requires evidence, all of this is a matter for trial. And
well, I mean, I sort of see it, but what I'm trying to understand is what is the unique element? I mean, actually what you're saying is they have destroyed a type of investment that we particularly like, but that sort of, you might imagine, was a wrong done to the whole thing rather than to the right to buy a share. One
yes, they've destroyed the brand, effectively.
Brand, but you don't own the brand as an investor in it, do you?
No, but by investing in the brand, if someone invests in the brand on the basis that that investor thinks the brand will be converted into a top-tier currency in due
And I mean,
course.
that's my Lord's point. I mean, how can you, if you invest in anything and you put £100 in it, how can you get more than £100? That's really the point.
Well, I've answered that, or haven't answered it.
You said you see the point, I think you said.
Yes, I see the point.
So, okay, maybe a very simple case.
Unless anyone wants a better answer behind me, I do see that point. But I would still say it's not appropriate to strike out at this stage.
What, a claim for more than £100?
Exactly. I would say precisely what BSV is, how unique it is, whether or not there's a substitute, how reasonable was it to hang on to the coins after, or the crypto after the delisting. It all requires evidence, what we would say.
Well, I mean, I think, to put it more simply than perhaps the judge put it, I think the point that you can't get, for any sort of fungible investment, you can't get more than £100 is quite a strong point against you.
As I say, I see the point.
Because you're trying to get, I mean, how many times the current value of the asset are you trying to reclaim in this?
Oh, many, many, many times over.
Right, by using the words foregone something effect.
Foregone
growth effect.
Foregone growth effect.
Which I can't remember, despite having been looking at these papers for 10 days now. I completely can't remember the words foregone growth effect, which strikes me as something, therefore must be wrong with it. Okay, well, there we are. So what are the authorities that bear on all this?
Well, can I just
Where
tell you
is
where
the authority that says you can get more than 100 for damage to an asset of this kind?
I haven't got one.
Okay.
So,
Can I tell you where I was going to go?
Yes.
And see.
I'm sorry, we've taken you out of your course, Mr.
Yes.
Moore. We don't have all that much time for this case, as you know.
I know.
In addition to that, at 12 o'clock, we will be observing 2 minutes silence for VE Day.
Of course.
Yes.
So, our position in respect to ground one, in summary, is this. Before one gets to the question of whether or not there was a substitute cryptocurrency, we say there's some fundamental problems in applying the market mitigation rule at this stage. That's because the market mitigation rule is not an inflexible one, and indeed the Supreme Court confirmed in the Stanford International Bank case that I'll come to later, that there is no rule of law that loss is to be calculated at the breach date. Secondly, we say an additional issue arises in tort cases where the defendant, as here, has damaged the claimant's asset. the members of subclass B have already paid out for the asset, so their ability to acquire a substitute is dependent on the ability to sell the damaged asset to release the funds to acquire other coin, alternatively to trade their coin for an alternative. Now, if all investors are required to take that step, then the value of BSV would plummet, potentially rendering it of nil value such that the investors would have no funds with which to acquire a substitute. In this regard, the law doesn't require the investors to spend yet more money to acquire a substitute if they cannot realise value from the damaged asset so as to acquire the substitute. Thirdly, in the context of cryptocurrencies generally, we submit that it's an open question as to whether the market mitigation rules should apply, and certainly this is not something that should have been decided on a summary basis. And the applicability or otherwise of the rule in the crypto context has been considered at first instance in the High Court of Singapore in the Phantom Foundation case, which I'll come on to. Fourthly, we say that there's no law on how the rule should apply in the context of a class action. Does the rule impose upon each investor the same obligations to mitigate in the specific way prescribed by the rule when there are 75,000 of them? And that raises the question of whether or not individual investor profile has any relevance. And in light of the tribunal's ruling about when investors became aware of the delisting, it would appear to be relevant, even though it's not clear how in practice such an issue will be resolved. And finally, and in any case, the rule is premised on there being an available market in which the claimant can acquire a substitute for what he has lost. Whether such a substitute exists here is an open question, and one which would require evidence from experts in cryptocurrencies in order to consider substitutability within the meaning of the authorities. The class representatives adduced evidence from Robin Noble, as you know, in an attempt to quantify, by reference to other cryptocurrencies, how BSV might have increased in value but for the infringement. And that is self-evidently, we say, a different exercise from assessing whether or not those currencies are substitutable within the meaning of the market mitigation rule. So that, in summary, is what we want to develop in respect of ground one. So starting with the market mitigation rule, there's a great deal of common ground between the parties about this, but it is important, we say, to set out the jurisprudential context. And the starting point, of course, is the measure of damages is the sum of money which will put the innocent party in the same position he would have been had the tort not occurred. And the locus classicus of that proposition is, of course, Lord Blackburn's judgment in Livingston and Raywood's Coal, and that will need no introduction. For your note, it can be found at the Authorities Bundle, tab 1 at page 19. And Lord Blackburn says this: I don't think there's any difference of opinion as to it being a general rule that where an injury is to be compensated by damages, in setting the sum of money to be given for reparation of damages, you should, as nearly as possible, get that sum of money which will put the party who's been injured or has suffered in the same position as he would have been in if he had not sustained the wrong for which he was now getting compensation or reparation. And that, of course, reflects the basic compensatory principle and the law of causation of damages.
But I mean, the argument here cannot go beyond the difference between assessment as at the date of the tort and assessment as at the date of trial. You can't have assessment as at the date of 20 years in the future. Surely.
No, I agree.
That's what you're asking for.
The assessment has to be at the date of trial if it's
the
not
date
at
of
the date
trial,
of
I mean, Mr. Noble doesn't say BSV would be worth £1 million today at the date of trial and you should assess at the date of trial. He says it might in the future have become very valuable and therefore you can have $86 billion. Well, can you? I mean, you've already agreed with me you can't. There's no case that says you can. I mean, if my antique table I mean, I know my lord says antique tables and crypto assets are not the same, and he's right. But if my antique table is worth 100 at the date of the axe and 200 at the date of the trial, you might argue 200 is the damages. But you could not argue 2,000 is the damages because it was going to be valuable in the never, never future. You just, that's bad luck.
And even if it was going to be valuable, worth 2,000 in 10 years' time, in 15 years' time, might be worth next to nothing because nobody wants antique tables.
Yes, which is my experience.
Which is the position today.
Quite.
Yes.
Stuff from IKEA is more expensive than what was once a very valuable tall boy or antique table.
But my lord's point is the reason why you can't get speculative damages for what might happen in the future. So why should you here?
Well, I've already given you my not very persuasive answer. I see the point.
No, but I mean, that's your whole appeal.
Well, the whole appeal, no, it's not, no, with respect, it's not, because the tribunal has said, on any view, it has to be assessed at date of breach. Now, I get the points about not being able to take it beyond the date of trial, but the same arguments that support the appeal on the foregone growth effect, that however much people might dislike the phraseology, the precisely the same arguments go to the proposition that the CAT should not at this stage have decided that date of breach rather than date of trial is the right date of assessment.
And I certainly get that point.
Well, and that's my appeal, effectively. That's where we say they went wrong. And that the proposition that one should leave it to the date of trial holds good, we say, in precisely the same way as I was going to develop the appeal anyway.
Right. And where is that stated? I mean, can you just show me where in the judgment it says must be date of breach?
Yes. So, where? I think it's around paragraph 60. Bear with me a second, please. So they start the discussion of the market mitigation rule at paragraph 39.
Yes, I wasn't near that, but I think it's...
And the conclusion,
according to the registrar, was at 64 and 65.
yes. They say at 64 line 4, the relevant question is whether there was at the time the delisting events an available market on which substitutable cryptocurrency investments could have been made.
And
Mr. Noble's evidence confirmed that there was such a market. And then we say at 65 that Mr. Noble's evidence is provisional.
Yeah, but it doesn't say what the date of loss is.
Well, my learned friend's argument was all about the measure of damages should be the market. Sorry,
I mean, this is the totally unsatisfactory nature of not having a decision.
Yes, I see
We've
that.
just got reasoning.
But their decision would have been the market mitigation rule applies here, and therefore loss must be assessed at date of breach. That's their decision, and that's what we're effectively appealing against.
Right.
Subject, of course, to the point that they said the one trial issue in that is when the individual holders became aware. But their effect, once that has been decided, their decision is market mitigation rule applies. So as soon as you became aware, you have to go into the market and you buy a substitute, and they say that Mr. Noble's report, albeit dealing with an entirely different point, identifies that substitute. I was going to take you to some of the fairly recent Supreme Court decisions on market mitigation, which we've addressed in our skeleton.
Just before you take, just for me, just before you take us to the authorities, can we just look at Kraken and subcategory C in relation to Kraken for a second? As I understand it from your skeleton, and I'm sure it's somewhere in this pleading, in respect of people who had BSV listed on Kraken, the facts are, as I understand it, that the Kraken exchange said, we will exchange your BSV for Bitcoin.
Yes.
On a certain date.
Yes.
So on the defined date, the holders of BSV had their holdings of BSV converted to Bitcoin.
Yes.
Right? In relation to those people, you are not claiming, as I understand it, foregone growth effect.
No.
And that's because, is it, that you recognise that Bitcoin is an appropriate exchange conversion thing into which BSV could be converted and would have its own future growth, so that you don't claim the foregone growth effect in relation to people who had their BSV converted to Bitcoin.
I don't think that's the way Mr. Noble puts it or addresses it.
It may not be, but if somebody who had their BSV converted to Bitcoin doesn't claim foregone growth effect, everybody can buy Bitcoin out there. So why couldn't all the people who were given their BSV on a certain date just go and buy Bitcoin?
Well,
I mean, why isn't Bitcoin on that basis
well, I'm going to come to
an alternative?
I'm going to come to the question of substitute in due course, if I may.
Okay, but why are you not claiming foregone growth effect in relation to people who had BSV converted to Bitcoin?
You could ask the same question in respect of subclass A, and I'm afraid I don't know the answer. I think, on the face of it, I see a tension between the approach in respect to subclass A and Kraken in subclass C on the one hand, and subclass B and Binance in subclass C on the other. I personally would suggest there is an internal tension there, but I would just come back to the point that these are all matters for trial. You're asking me to second guess.
Well, I'm asking you actually just about your own claim.
Yes.
I mean, I appreciate it's not your personal pleading, it's not your name at the bottom of it.
No, it's not.
But it's your client's pleading, and I'm just trying to understand why somebody who got Bitcoin instead of BSV, this is a straightforward Kraken conversion, gets, as I understand it, the difference between, or the diminution in the conversion rate,
yes,
which might have been suffered as a consequence of this reputational damage,
yes,
plus the fee charged for conversion,
yes,
but does not get the foregone growth effect, which we're all here busily arguing about.
Well, I accept it's my client's claim, but I'm afraid Mr. Noble just doesn't explain that, and I haven't met Mr. Noble, spoken to him.
But Mr. Noble's not a lawyer. I mean, my lord put the point. Yes. Can we just put this in legal terms? Why is that foregone growth effect not being claimed for people who get Bitcoin instead of BSV?
I think that the view was taken that those who ended up with other cryptocurrencies would only be entitled to recover the loss of value that obtained as at the date of the exchange into another cryptocurrency.
Does that not mean that Bitcoin is treated as an appropriate market into which you can reinvest your...
I don't accept that necessarily
damaged
follows.
goods. Because I mean, what's happened there is you've, to take the table example, if you can, an exchange of tables, but your thing has been damaged by the damage to the reputation. It's been compulsorily converted into something else.
Yes.
And it seems to be accepted that the something else has full growth effect built into it, so you can't claim it.
It's accepted that that's when the loss crystallised, and that's all that they can recover as at the date of crystallisation. But those in subclass...
Why isn't it the same for everybody else? Because everybody else could just, if they wanted to, buy Bitcoin.
Well, then the question is whether or not they were under a duty, whether reasonable mitigation required them to do that at that time. That's a $64,000 question. And I accept the questions you put to me about the future, but whether or not the loss should be assessed as a breach or a trial for holders of subclass B, it is the only issue before you, and we would submit that plainly it's not an appropriate issue to decide on a summary strikeout basis. It may turn out at trial, after all the evidence is given, it may turn out that the court decides the appropriate time to assess the loss is at date of breach. But that's not something that should happen at this stage.
So what did they actually decide? I mean, in words of one syllable.
They decided that the holders of the BSV should have gone out at the date of the tort and bought a replacement cryptocurrency. And that was the date at which the loss should be assessed. Even...
Which date?
The date of the tort.
Date of?
The date they became aware of the delisting, they should have gone out, bought a substitute. And we don't know what date it is for each of the 75,000 members, because that's an issue that wasn't before the tribunal, and the tribunal held over.
Well, what does date of breach mean in this context? And where do they say it's the date of breach? Or is it the date of closure of the delisting on the particular exchange? Or is it a date dependent on the individual circumstances of the holder?
Well, if the holder was aware of it, of the delisting, as at the date it happened, then the tribunal's ruling is, as I understand it, that holder should at that stage have gone into the market and bought a replacement.
When?
If it was aware of the delisting.
When should they have done so?
June 2019, isn't it?
I mean, normally in judgments it actually says what they're deciding. Can you take me to the passage where I don't understand paragraph 64 and 65, which we've looked at. Yeah, I simply understand that as saying that the relevant question is whether at the time of delisting and thereafter an available market could have been made. And I understand the decision that there was an available market. What I don't understand is what that means in the terms of this case, or maybe they didn't decide that.
Let's go back to the judgment. My understanding is they decided that there was only one point that could be left over, which was the date of awareness of the individual members, the individual holders.
Well, how can that be? I mean, is it being? What's being said? Is it being said the minute you know, you have to sell that minute?
They say duty to mitigate arises as soon as you know. So you have to go into the market and buy a substitute cryptocurrency.
That minute, or do you get a period of leeway?
They didn't deal with that.
So how do we know what's open for trial? Without an order, how do we know what's open for trial? This is what I find so perplexing about this case.
Can we have a look at paragraph 79 of the judgment,
Yeah.
which we'll find in the core bundle?
Well, we got the judgment. Yeah.
So at 79, they say, line 4, we consider the evidence before us just about crosses the threshold, providing a realistic basis for the proposition that at least some BSV holders may reasonably have remained unaware of the delisting events throughout the relevant period. We're also mindful of the point that we must consider not only the evidence before us, but also the evidence that can reasonably be expected. We consider it reasonable to expect at least some further relevant evidence may be available at trial as to what BSV holders can be expected to know in the delisting event. It follows from our conclusion on the awareness issue at 80 that the subclass B claim cannot be struck out or summarily dismissed.
Yeah.
So what they're saying is the market mitigation rule applies. As soon as you're aware of the...
Well, where does it say that there? It doesn't say that at all.
They've said that en route to getting there in their discussion starting at paragraph 39. Paragraph 56 on page 63, that being the case, whatever price BSV might have fallen to, its holders could have replaced their holdings with another cryptocurrency. In principle, therefore, their loss should be based on the cost to those holders of doing so. And then at 57, they debate the reasonableness of divestment, and they say, next question is whether it's reasonable to expect BSV holders to have divested their holdings following the delisting events.
Well, they say at 68 that the question is the point of time at which it was reasonable for the claimant to enter into a substitute transaction, and that once that point of time is established, the rule requires evaluation of damages at that point. But I'm not sure that they go on thereafter to answer the question of what is the applicable point in time, save that they draw a distinction for those who were not aware of the delisting events.
But by the time we get to 68, they've decided that the market mitigation rule applies. And therefore, in any case, in any sale of goods case, the question would arise, how quickly do you need to go into the market to buy the replacement?
But they don't deal with the date at which assessment is to be made, do they? So that's open, is it?
No, I don't think it is. It's only open to the extent to which they haven't reached a conclusion about the date of each individual's awareness. If the evidence before the tribunal had been that all members of subclass B knew about the delisting event, their conclusion would have been that the claim for foregone growth would be struck out on the basis that the market mitigation rule applies. And
I mean,
market
you know, I know you love foregone growth effect, but the foregone growth effect seems to me to be saying I can have the highest value of the future value of a speculative currency in the future without having any regard to the fact that it might be worth nothing a day later. And that is not the law. That is not the law even for compensating a breach of trust. So it's certainly not the law for compensating.
Probably accepted in the course of argument with you that the issue would be, if you allowed this to go to trial, whether the assessment of loss should be at the date of the tort or at the date of the trial.
Yes, but that's the only issue.
Yes.
I mean, you cannot have a situation. There is no tort that can be compensated by. I mean, there was a case I did years ago where I exploded this myth that you can claim the highest intermediate value. I can't remember the context, I'm afraid, but it is fairly obvious that you can't have the highest intermediate value if you invest in shares or anything else that is a volatile commodity or investment or market asset. So are you really asking us to say that you can, by reinstating this so-called foregone growth effect, which I now call FGE, which is very easily memorable in my notes, is that really what we're here to argue, that you can have the highest intermediate value? I mean, Bitcoin and BSV are assets that go like this.
Yes, absolutely.
You know, all over the place. That's
Yes.
what they are. And people know that, and they love it, apparently, because there is $3 trillion of it in the world, I understand, Bitcoin. Now, so that's marvelous. But if you invest in Bitcoin and somebody takes it away from you, you cannot go to the court and say, I want the highest intermediate value in the next 10 years that Bitcoin arrives at, obviously.
All I think I'm asking this court to do is to find or to hold that the question of the date of the assessment of loss
Right, hang
should
on,
be...
say this very slowly because I need to write that down. It might appear in my judgment. All I need this court to do
is to find or direct that the question of the date of the assessment of the loss is a matter for trial rather than a matter for strikeout reverse summary judgment.
Now, maybe I'll ask Mr. Kennelly whether he agrees that that would be a reasonable thing to say. I mean, if you don't want to, you don't have to. No, you don't want to. Okay.
I won't break my learned friend's flow. I'll come to it when
You don't agree.
I'm sorry, my lord.
You don't agree that the date of loss remains open.
It doesn't remain entirely open, no.
Sorry?
Sorry, the date of assessment does remain open.
Right. Great. Thank you. Date of assessment remains open, so you're at 1. Marvellous.
This is certainly, yes, certainly not how I read what he's argued, or...
I'm sorry, so just to be absolutely clear, it remains open, subject to the market mitigation rule, but it remains open because the question of awareness remains open for trial, as the tribunal found.
But that's the only... If the tribunal's ruling stands, that is the only issue that remains open. So that if in fact it turns out that all 75,000 members were aware of the delisting when it happened, my learned friend would argue that that is the date at which the loss...
So let me ask Mr. Kennelly one last question before we interrupt your submissions any further, Mr. So, Mr. Kennelly, if there is one investor who became aware of the delisting on a date in July 2019, is it open to that investor to say, I took 3 months to think about it, and I should have my damages assessed 3 months later, or 2 months later, or on another date, apart from the date on which I became aware?
Yes, in this context, because we're dealing with a class claim.
Yes.
And so the question of awareness, which falls to be assessed on the tribunal's judgment, is the class as a whole. And the tribunal held, and we'll come to this, that the tribunal could not conclude, looking at the class as a whole, whether it could be determined at the summary judgment stage that they were sufficiently aware of the breach, the alleged breach, to trigger the operation of the market mitigation rule. And that's what remains to be determined. And that question of awareness will be determined if the appeal is rejected as a preliminary issue by the tribunal. Now, there may be an individual in the class who unusually became aware very late in the day and may have had good reason for his or her lack of awareness, that person has the option of opting out of the claim and bringing his or her own claim where those individual circumstances can be canvassed before the tribunal.
It's extremely helpful, thank you.
But what my learned friend is saying is that CAT decided that awareness triggers a market mitigation rule. So if there was awareness at the date of breach, the loss is assessed as at date.
Yes, but as a matter of class, it could be held that you could argue that the class awareness, right, should have been at X date, and there should have been a month in which you sold it, or to mitigate your loss. So that's, but not 10 years. You can't choose to keep it in the hope that it will become massively valuable in the future, because that is equivalent to the highest intermediate value claim.
But that assumes that the market mitigation rule applies in this case.
Yes, but why should it not apply?
Well, that's
in
what
in that sense. I'm beginning to see why it's said it must apply, because it's really just a question of assessment of loss. I mean, you could argue that they should have 2 years until trial to decide, and therefore even though the market mitigation rule applies, you should have been allowed until trial to decide. But you can't have a value beyond trial.
But I'm not as I said earlier, what I invite this court to direct is that the question of the data assessment it is not limited to application of the market mitigation rule coupled with awareness. That's what the appeal from this side.
But what is it? What is it? I mean, it must have some limitation. It must be limited to the law and the market awareness, which is obviously a relevant fact, and the fact that there is a market.
Well, the question that arises, when an individual in the class becomes aware, is he obliged to mitigate his loss by going to acquire a substitute cryptocurrency? Now, ignoring whether he has to do it in a day or a week or a month, the question is does the duty to mitigate bite at that stage? The tribunal have held, yes, it does. We want to be able to argue that the question of whether or not that obligation bites at that stage is a matter for trial, because there is no substitute cryptocurrency that was available to be bought.
Except for subclass C on Kraken, you seem to just be left with Bitcoin and you're happy with it.
Apparently so, yes.
So I want to get this down as well. You want to argue that whether or not the market mitigation rule bites at the stage of awareness.
Apologies for interrupting. I'd put it more simply than that.
Okay.
I want to argue that the market mitigation rule does not apply. Full stop.
I don't think you do.
I do want to argue that in respect of subclass B.
Well, but you're accepting that the latest possible valuation date is the date of trial.
Yes.
And if you accept the latest possible valuation date is the date of trial, then you are accepting that a form of the market mitigation rule does apply.
I'm not sure I'd accept it's the form of the market mitigation rule, because the market
It
mitigation...
doesn't matter, does it? Because if he accepts that you can argue on the basis of when you became aware,
But that's a much narrower time frame. If you just leave the only question open as a when did the person become aware?
What other questions are you trying to keep open apart from awareness? What
I want
are
to
you
leave
going to
open
say
the
at
question
trial?
that it was reasonable. Sorry, I want to be able to argue that it was reasonable for the people in subclass B to hold on to their BSV, and that therefore the loss that they've sustained should be assessed as at the date of trial, which would include some of Mr. Noble's foregone growth effect, because Mr. Noble would, I hope in a supplementary report, would be able to say that but for the tort, the BSV would have been worth this amount by this stage, where in fact it's now only worth that amount, and therefore the difference between the two would be recoverable. I don't want to be shackled by the market mitigation rule. My learned friend sought to strike out the claim on the basis that the market mitigation rule applied. He succeeded in persuading the tribunal that the market mitigation rule applied, and the only reason he wasn't successful in striking out the entirety of that claim was the awareness point. And I don't want to be shackled by the only issues at trial are awareness. And then, once you're aware, what's the time frame imposed by the market mitigation rule?
But on what basis would it be reasonable, having assumed the Kraken point that my lord has established with you, on what basis would it be reasonable, apart from awareness, for you to keep the BSV till trial?
Because the value might recover, because for particular reasons the holder doesn't want to buy alternative cryptocurrencies, and because as one's dealing
Hang
with...
on, I want to take these down.
Sorry.
One, because holder might not want to buy alternative, might not want to buy alternatives. Two, value might increase.
Yes. Three, this being a tort case, there's no requirement for the holder of damaged property to go out and spend money to buy an alternative. The paradigm market mitigation rule assumes that the owner or rather the innocent party has the funds with which to buy a replacement. We say there's no obligation under the market mitigation rule to invest further funds. And so in a conversion case where goods are misappropriated, the claimant can recover consequential losses arising from the increases in value of the goods between the date of conversion and the earliest time the action could have been brought to trial. Can I show you an extract in McGregor, please, in the authorities bundle, tab little a, page 1353.
I think I must have completely misheard the reference.
But it's authorities bundle little a, page 1353. There's a little tab A at the end of all the other.
Yeah. Okay. Sorry, it's not.
So the end, after 36, you've got little tab A, little tab B, and little tab C.
Is in McGregor on damage?
Yes. And McGregor says this: the reason for basing the damages for failure to deliver goods in breach of contract are not the damages for tortious misappropriation of goods, upon the assumption of a replacement may be that in the case of contract, claimants will generally still have available for purchasing a replacement in the market the money with which they intended to pay the price, a factor which has no application in the cases of tort. From this reasoning, it should follow that even in contract, claimants should not be restricted in their damages by reason of an assumption of replacement of the goods if they had already paid the contract price for them to the defendant. Now, this obviously isn't a conversion case, but the reasoning in that passage is equally applicable here. The holders of the coin, the BSV, have sunk their money into the BSV, and there's no obligation on them to sink further money to buy a replacement. And that passage was endorsed by Mr. Justice Trower in a case called Southgate and Graham, which was a crypto case concerning a failure to repay the crypto debt. You'll find that at Authorities Bundle, tab 34, page 1306. And at 58, he says he refers to the passage in McGregor with approval, and at 61 at page 1307, he says the question of what the creditor could and should have done once the breach of the oral agreement became clear to him, in circumstances in which, unlike a normal unperformed contract for the transfer or delivery of property, he had already performed his side of the bargain, is one which requires a factual inquiry. So we say that applies equally here. The means of obtaining a substitute is premised on the liquidation of the BSV in order to obtain the substitute or direct trade. But that assumes that the BSV has a value that can be traded. But whilst it's right that those in subclass A sold their BSV, if it's right that all investors should have traded in their BSV, that will or might lead to a run whereby its value is eradicated. And that point is made by Mr. Noble in his second report.
Well, why shouldn't you have the case struck out on the basis that it claims more than 100% of the value of BSV as at the date of the loss, as at the date of the...
But you can only do that if the market mitigation rule applies. And there's no obligation to, we say that, and the market mitigation rule is all about being obliged, acting reasonably to go into the market to acquire a replacement. We say that rule has no application if in fact you've already acquired the asset. And therefore, when approaching the question of loss at trial, it will be open to the claimants to argue that for those who've hung on to their BSV, that this BSV would now be worth X. But for the court. And can I show you, please, Mr. Noble's second report, which you find in the supplementary bundle, tab 6, page 227.
But why is this a relevant consideration? Because if you take the antique table example, the damages are the value of the table, whatever.
But not as a net. Sorry.
And that doesn't depend on whether you did or didn't have the money to go out and buy another table.
If you apply the market mitigation rule, you take the value of the table as at the date of the tort. But we would say that the owner of that table is allowed to argue at trial it would now be worth so much more. And we've had that debate earlier. And the market mitigation rule, if applicable, prevents the owner of the table being able to argue it would now be worth so much more. So the question is, does the rule apply? And one reason why the rule doesn't apply is because there is no obligation to go out and spend further money on acquiring an alternative. And that's the point that Mr. Noble, or rather the point that Mr. Noble makes in his second report at page 227 of tab 6 of the supplementary bundle, where he says the Binance strikeout application is asserted on the basis that all proposed class members in subclass B could have mitigated their losses if they'd sold immediately. This is also an example of a fallacy of composition. If all proposed class members in subclass B had sold their BSV, this would, holding other factors constant, have increased supply without any countervailing increase in demand. This would tend to reduce the price of BSV. If divesting from BSV is optimal for members of subclass B, it would also be optimum for members of subclass A. If every BSV investor around the world who could divest had done so, the price of BSV would have fallen dramatically. Had that happened, only the sellers of BSV who moved fastest would have seen any benefit. So the point he's making is that if everyone is required to sell as at the date of breach, then the price of BSV will plummet, might become worthless, and the market mitigation rule does not require the holder of the asset to spend money, additional sums, on buying a replacement. So we say there's real scope for argument of whether the market mitigation rules should apply in a tort case, where the claimant has acquired the asset, expended funds in doing so, and then the asset is damaged to the effect that it has no residual value. And whilst it's true that losses incurred in taking mitigating steps are recoverable, it's not the law of mitigation that an innocent party is required.
Attention please. This is the Security Control Office. You are now invited to observe a 2-minute silence to mark the 80th anniversary of VE Day. Thank you.
So the point I was just making, my lords, was that there's no obligation to spend further money to go and buy a substitute, or even if assuming a substitute is available. But even assuming that such an obligation does exist there, it's also well established that claimants will not be prejudiced by their financial inability to take steps in mitigation. That's McGregor again. I'm sure you're very familiar with that. You find that on page 1356 of the authorities bundle. And that goes back to the dictum of Lord Collins and Clippins Oil Company and against Edinburgh and District Water Trustees. In my opinion, the wrongdoer must take his victim Talem Qualem if the position of the latter is aggravated because he's without the means of mitigating it. So much the worse the wrongdoer has got to be answerable for the consequences flowing from his tortious act. And they go on to refer to the Dodds and Canterbury City Council case, where the Court of Appeal awarded the claimants the higher cost of repair of their building, which had been damaged by the defendants at the time of the action, since they'd been financially unable to effect repairs at the time the damage had been done. So we just don't know to what extent the individual holders in this case, had the wherewithal.
Well, surely the answer to that is the same one that Mr. Kennelly gave in relation to the thing. They can opt out and say, I couldn't mitigate in this case because I had no money and I couldn't sell for various reasons, and so I should get more than the others. But I mean, ultimately, you can't get more than the value of what you lost. You can't get the speculative future value, which is what this,
We've
if
had
I may
that.
say so, words FGE seem to connote.
We've had that debate, but all I'm asking, I'm limiting my appeal in
Yeah.
respect of the holders.
Well, let's look at your grounds of appeal, shall we, and see what you actually are appealing. I always find that rather educative. So your ground one, leaving the loss of a chance aside. What you're actually appealing is that the market mitigation rule makes the claim by reference to the foregone growth effect irrecoverable in law, subject only to the question of awareness of the delisting events. So you are claiming the right to argue foregone growth effect in all its glory.
Well, that's certainly how the grounds of appeal are put, yeah.
Well, that's what you're entitled to argue. And the foregone growth effect is 86 billion pounds or euros or dollars or something for what face value?
Oh, small. I mean, it's only one way of putting the foregone growth effect.
Well, that's the bit that's objectionable, isn't it? The bit that's not, I mean, I know Mr. Kennelly says that what he said, but, and I can understand why he says it, but it might be less objectionable if you had just said, I want to be able to argue that I can have it assessed at the date of trial.
Well,
Then the question of whether it's called the market mitigation rule or not. I mean, the market mitigation rule is not binary either. You know, it's binary in some cases where you're talking about freely tradable shares in, you know, General Electric, but it may not be binary in other cases.
yes, well, I think I made it clear that I'm seeking to, if you will permit me, I'm seeking to limit the appeal to the ability of the claimants to argue that the holders in subclass B should have their loss assessed at date of trial.
Yes, well, that's I've heard that. But the difficulty, the problem here is caused by cases being pleaded by reference to evidence, and it really is important, just for future reference, that this is not done.
I completely understand that. I'm not.
Chaos.
I'm not
Causes
seeking
chaos.
to argue against that.
You know, and it happens more in the CAT than elsewhere, because often cases are pleaded by reference to the evidence of economists.
Yeah, which is what's happened here.
Well, I don't know whether Mr. Nable's an economist or not, but whether he is or not, that's what generally happens, and it's not helpful. What we need is pleadings by reference to facts and legal claims.
Can I just show you where
The difficulty arises in the CAT. The difficulty arises in that respect in the CAT, doesn't it? Because it's necessary when you're seeking to get collective proceedings certified, you need to show a methodology for determination of loss, which is almost invariably based upon expert economic evidence.
Yes.
The problem that my lord has identified is that it's wrong to allow that sort of approach to also rule the questions of what is the cause of action, what facts are you relying upon for breach, and what is your loss as a matter of law. And the trouble is that people have become very sloppy at allowing the economic analysis to bleed backwards into what should be properly legal pleadings.
Yeah. Well, completely accept that. I mean, it's not my area. I don't appear in the CAT, but I completely accept the criticism. but I am here to try and preserve for the holders of subclass B the ability to argue that their loss should be assessed at date of trial without being subject to the constraint of being required to have gone out to sell to replace their BSV within a reasonable time of their awareness of the delisting. So I'm seeking to argue what is now a very narrow point. I accept that, and I accept that the grounds of appeal are put more widely. But I do want to show you where the tribunal went wrong about it, when considering the question of the.
If your appeal were to succeed on that basis, then where would that leave the proceedings? There'd be whole different categories of claimants, even within subclass B. There'd be some who knew about the share, knew about the delisting event, and some who didn't, and some who knew about the delisting and decided to sell, and some who didn't, and some who wanted to have their claims determined by reference to the date of the trial, and maybe others who didn't, and it's beginning to sound less and less like a class, isn't it? Unless vast numbers of them are going to opt out.
Well, if we would be arguing for subclass B that the entirety of that class's loss should be assessed at date of trial, we'd be arguing that the market mitigation rule does not apply if we were permitted to do so, and that therefore the question of awareness of the delisting is irrelevant. We'd be saying, here's subclass B, they all hold BSV, the date at which their loss should be assessed is the date of trial, and no distinction needs to be drawn between individual holders of the BSV within that class.
So those who did know about the delisting events and could have sold, and even had the money to buy an alternative cryptocurrency if that was what they wanted to do, but who decided, actually, I think BSV is still a pretty good investment, I'm going to hold on to it,
yeah.
Would get the benefit of that decision, which on conventional damages approach is regarded as a decision which is independent of the breach.
Well, we would say they're under no obligation to sell because of the point, the first point I made about the financial position. They've sunk their money into the asset.
Well, I was positing to you somebody who had the money.
No, that's the impecuniosity point. That's the second point. There are 2 points about the financial aspect. Point one is the duty to mitigate by selling does not apply if your damaged asset cannot generate sufficient funds to buy the substitute, assuming there is a substitute available. And that's why I took you to the passage in McGregor. That's nothing to do with the question of whether you've got other funds you can expend. It's whether or not the BSV actually has value. And the point that Mr. Noble puts forward, the fallacy of composition, is that if everyone in the class was duty bound to sell as at the date of delisting, assuming for the moment that everyone in that class had the relevant knowledge, that would reduce the value of BSV to nil or approaching nil, so that you couldn't use the BSV to acquire a substitute. And in that event, the laws to mitigation does not require you to spend more money on acquiring the substitute, and we rely on that for the case of Bittylicious, which you'll find in. Well, before I take to Bittylicious, I just want to show you where I say the tribunal went wrong about this, which is paragraph. Paragraph 54 of the judgment, core bundle, tab 4, page 62, please. On paragraph 54, they refer to the fallacy of composition argument, when they say it may well be that if the entirety of subclass B had divested their BSV holdings following the delisting events, the price of BSV would have been lower than it was in fact in circumstances where some but not all BSV holders sold their coins. If that were to be established, the consequence would be an increased immediate and persistent effect loss for that class, reflecting the greater loss in value of the relevant BSV holdings. That loss would represent, however, the entirety of the loss to that class. If those BSV holders could immediately have replaced their BSV holdings with holdings in another substitutable cryptocurrency. We note in this regard that there's no suggestion that any of the BSV holders lacked the funds to reinvest. So we say that they fell into error because they assumed that the innocent party is obliged to reinvest using additional funds beyond that which he can obtain by sale of the damaged asset. And we say they were wrong to conclude that. They go on to rely on the case of Bittylicious, which I'll take you to in a second. We deal with that in paragraph 60 to 61. And they say that that has no application because it preceded the development of the market mitigation rule. Now, the Bittylicious you can find at Authorities Bundle 4, tab 4, that is, page 49. And the judge said that the holding is very short over the page at 50. Although it's the plaintiff's duty to minimise the damages, he was under no obligation to spend money for that purpose. So there's no obligation.
Sorry, where are you?
I'm reading from that.
Held that although it was the plaintiff's duty to mitigate, to minimise, he has no obligation to spend money for that purpose.
Exactly.
Bittylicious.
Yes, and we say that they didn't follow this on the basis they said it preceded the development of the market mitigation rule. Now, we of course accept that Bittylicious predates the Supreme Court decision starting from the Golden Victory, but the market mitigation rule, breach date rule, was in place long before those cases. One of the earliest manifestations of it was in the section 51.3 of the Sale of Goods Act 1893, quoted in the Golden Victory by Lord Brown. You'll find that Authorities Bundle, tab 12, page 256. And at paragraph,
Sorry, can you give me the reference again?
of course, it's tab 12, page 256, and it's paragraph 79. He quotes from the 1893 Sale of Goods Act, and my understanding is that that just codified the common law. And without looking it up, Lord Bingham, in his judgment at paragraph 11 at page 231, I don't think we need to go there, referred to jurisprudence about the market breach rule, market data breach rule back to the 1916 case of Jamal and Muller, and we say there's nothing to suggest that Mr. Justice Lewis in Bittylicious was not well versed in the jurisprudence.
Well, I mean, in the Golden, whatever it's called, Golden Victory, essentially says Lord Brown it applies whenever there's an available market for whatever's been lost, and its explanation is that the injured party should ordinarily have gone out into the market to mitigate his loss.
If there is a
market price moves up and down. If the injured party delays unjustifiably in re-entering the market, he does so at his own risk. Future speculation is to his account.
But that's if the rule applies, and that assumes that you've got, in the case of a damaged asset, it assumes that you can sell the asset to go into the market and buy a substitute.
So you say it does not apply whenever there's an available market for what has been lost. You accept there is an available market because my lord's point in category C, but you say it doesn't apply here because, just remind me what the...
I don't accept my Lord Justice Snowden's point that the way the Kraken case is put means that there was a substitute, a reasonably adequate or an adequate substitute for the BSV. It's just what happened is that Kraken decided to replace the BSV with Bitcoin.
But I think my point to you was that if you don't accept that Bitcoin was an adequate substitute, why aren't you claiming for category C a whole load of extra foregone loss?
Well, we probably should have been, but again, it's not my. I wasn't here at the beginning. It's not my pleading.
I mean, I'm just testing it because, of course, we haven't really got onto this yet. But the reason that the CAT said that there was an obviously available substitute or an adequate substitute available in the market for BSV was by reference to Mr. Noble's reports, where he measures the foregone value, which he said to which BSV would have risen if it hadn't had the damage done to it reputationally against Bitcoin and Bitcoin Cash.
Yes.
And I'm actually just pointing out that, in fact, even on the basis of the way the case is put on behalf of Category C, never mind Mr. Noble's report, it appears to be assumed, because I haven't heard an explanation to the contrary, that it's accepted that Bitcoin is an adequate substitute, because if that's not the basis on, I can't figure out any other basis on which Category C has been formulated.
Well, we
And
accept that the loss is claimed as limited in the way you've outlined, but we don't accept it.
Okay, but you haven't been shy. Sorry, your clients have not been shy about claiming loss here.
No.
I think that's fair. And yet, in relation to Category C, they have limited loss, which in a way that I just can't explain in any other way. At the moment, I mean, you may be able to come up with an explanation, but at the moment I don't know what it is.
Well, I would say they shouldn't have limited their loss in respect of Kraken. If they're right that you're entitled to recover
because it also is, to join the dots, the definition of foregone, I forget what it is, foregone FGE or whatever we're now calling it, the definition is of that concept is linked to the fact that BSV didn't become a sort of premier cryptocurrency.
That's the premise.
Like Bitcoin.
Noble's report. Yes.
Like Bitcoin.
Yes.
Can
I just show?
But Bitcoin is there. Why isn't Bitcoin therefore an available market?
Well, I'm going to come to substitution. I mean, can I just show you what Mr. Noble says about Kraken?
Okay.
It's supplemental bundle, page 48. I don't know whether this will help. Footnote 72 on page 48. He says, it may transpire that Kraken users in subclass C would have held on to BSV rather than selling. In such case, they may also be able to claim for the foregone growth effect. So
So this is a foregone growth effect that BSV would have been even better than Bitcoin.
yes, it's a foregone growth effect in respect of BSV, as a result of being able to become a competing or a first-tier cryptocurrency.
Where do we find the value of Category B's holdings as at the date of breach?
I'm sorry, my lord?
Where do we find the value of Category B's holdings as at the date of breach?
I don't think we have a total value. It's page...
We must do.
It's the 55.
Yeah.
Whether it was dollars or pounds.
Yes, we have
multiplied
details
by the number of coins in issue, presumably.
Yes, well, I don't think I have the figure for the
No,
number.
it's multiplied by the 75,000 holders and the number they held.
That's the number they
This
held.
is Category B I'm talking.
Yes.
The reason I'm asking is not just because I'm being awkward, which obviously you would assume against me. The reason I'm asking is because it is widely stated in the judgment and in your pleading and in lots of other places that you're claiming this figure of $86 billion or pounds on behalf of these 75,000 people, but it is not widely stated what the value of their holdings of BSV was at the date the breach happened. And I'd like to know whether that's, how many times the 86 billion is bigger than that.
So, if we can just go back to the table.
Which table?
Of the loss. I think it's 8 billion, isn't it? The highest claim. But if you look, if it's right comparative.
So, which table are you at?
I'm in skeleton argument, I apologise. Page 88, core bundle.
Skeleton argument. Yeah, I find that difficult because in the electronic version, the part of it is cut off.
I think if you
Maybe
move the cursor, it will stop being cut
It
off.
says, well, I've got it's headed class,
Yes.
and then it says a heading Bitcoin, and then it's got a one that says Bitco.
Can I ask what percentage you've got open in terms of?
No, it's very small. It's got it. It's the whole thing is open.
Oh,
It's just cut off.
I'm sorry about that.
So can you find me anyway? It doesn't matter because subclass C.
Bitcoin Cash, the claim is only 25.9 million. If that's a
Subclass B.
yes.
Total value of damages 8,991.9 million.
That's if Bitcoin is the right comparator. If Bitcoin Cash is the right comparator, the claim is 25.9 million.
I understand, but what I want to know is what is the value of on the basis that it was worth? Was it 55 pounds per
I'll see if we can find a figure.
unit? Thank you.
And before I forget, before I move on to my next point, can I just remind you of how the damages claim is pleaded? I don't think I've found this before. If you go to the supplemental bundle, page 138. The damages claimed, or damages calculated as at 21st of July 2022 being the date, the last practical date before the issue of the claim. So you were asking me what date we were seeking the loss, and the date is as at 21st of July. It's not a future date. So the point I just completed was that there's no obligation if your asset can't be, if you can't sell the asset on the market to raise money, there's no obligation to spend yet further money on a...
Does this reference you've just given us mean that your claim is as at the 21st of July 2022, or are you seeking, as it were, the option to extend it to the date of trial if that gives you a better figure?
The latter. And we have...
Sorry, the latter. Sorry, I didn't.
As at date of trial, the option to, if it's a higher figure at date of trial, to be seeking that.
And if it's a lower figure?
Well, it'd probably be very difficult to justify at date of trial taking an arbitrary date as at 21st of July just being the day before the issue proceedings. I get that. We can't. I don't see how one could
So it is a claim for the highest intermediate value.
No, exactly. My lord, you've already made that point, which is why I've answered the question the way that I have. Can I ask you to look at page 65 of the expert report of Mr. Noble? I think it's probably page 65 in the supplemental bundle.
Page 65.
Page 65, paragraph 721.
Yes.
And there he gives estimates of cash values pre-delisting, and you'll see figures in paragraph 721 for each class. So subclass B is 25 million.
Where's that?
That's total value of commerce, is how he puts it.
25.5 million. So this foregone growth effect, without trying to, is $3,600 times the value.
If the higher figure is taken. But if the lower figure is taken, I was going to make some observations about the particularity of crypto.
So I'm just doing my own maths there, but 3,600 times 25 million, 25.5 million is roughly 8 billion. Somebody will tell me if I'm wrong, because I might be.
Well, I'm not going to challenge your mental arithmetic at the
Well,
moment. I'll have a think about...
you'd be most unwise, Mr. Wardell, because I might well be wrong. But that's the point. I mean, that's what would have made the tribunal's eyes water.
Yes.
Because...
But that may be the tail wagging the dog.
Well...
It's a tail you're trying to wag.
That's true.
You see, if instead you said, I want to claim the value at the date of trial, any value intermediate between the of BSV up to the date of trial, or even an equivalent, you still don't get anywhere near that. I mean, you don't get above probably 25 million. So I just don't see how you can sustain. I mean, it sounds like a claim that is intending to hold a sword of Damocles over the defendants by having a claim of 86 billion they've got to put in their accounts. I mean, let's get some economic reality here. It is very damaging for major corporations. Binance, I don't know the others by name, but Binance is a major corporation. It's very damaging for Binance to have a sustainable claim against it for 86 billion, or how many, $9 billion.
9 billion. When
the real claim is 25 million. I mean, isn't that what this is all about, really?
I can't remember what figure you gave me. I'm told it's 360 times for what it's worth behind me.
Yes, I suspected I might have got a naught wrong, which is why I said I shouldn't be relied upon. No. But even if it's 360, it doesn't make the point any different.
Well, I see the point.
I mean, one might, if one were given to hyperbole, say it's outrageous, Mr. Wardell.
I'm afraid I missed that.
I said if you were given to hyperbole, you might say it's outrageous economically, because you're putting Binance in a position where they're facing a claim for 360 times the real value.
Yes.
And they shouldn't have to do that. So, but that said, I mean, I am sympathetic to the idea that you might want to raise all sorts of different arguments at trial that you haven't yet thought of, as between 0 and 25 million.
Yes.
What I find difficult about this case is it seems to me painfully obvious that the tribunal would have done much better to have had a section in their judgment that said this is what we are deciding and this is what we are not deciding.
Yeah.
And I'm sure the tribunal, had it been asked to do so, would have done that. The position that we're facing now is we have to deal with a sort of loose appeal that is trying to justify the unjustifiable, if I may say so, which is a claim for billions, when we're really dealing with a claim for millions.
Well, I can see why the court doesn't like a larger figure.
No, I don't like it.
And I'm
This
not,
member of the court does
I'm
not.
not going to try and persuade you that you should be liking it.
No. So
But I still don't want...
maybe you and Mr. Kennelly could go outside over lunch and find a formulation for an as to what could sensibly be argued at trial. I mean, because this is a summary judgment. I mean, it's the most inappropriate way of deciding cases, summary judgments. No evidence. There's a pleading by way of economist's report, and no proper pleading, as it appears, because it's all pleaded by reference to the economist's report. And Mr. Kennelly can probably see, from having heard the argument in the case, that he's not going to get away with cutting you off completely from arguing some stuff about data valuation or what people ought to have done. And there are complexities about the class. And the whole thing is thoroughly unsatisfactory for this court to have to make sweeping statements about the law on the basis of no facts and no proper evidence and no proper argument of the law. So what, with great respect, you should both be doing is going away and deciding what it's open to you to argue, and deciding what order ought to have been made if you'd had if you'd had the thought as to an order being the appropriate thing by the tribunal as to what's open and what's not open. Obviously, what's not open is to argue that you can have 360 times the value, but obviously what might be open is to make some sensible arguments about the date on which the valuation ought to have been made.
Well, I'm certainly happy to attempt to see
Okay,
whether
well, we'll carry on until 1 o'clock, and then you can have a go at that, because it strikes me that this is, the worst thing is to have to give judgments in this court, which are judgments of record, apply to lots of other cases, without full argument, without proper definition of the issue. And it's very unsatisfactory.
My next point was going to be make a few observations. I'm not seeking...
No, I know you're not seeking to push back.
No, I'm not.
Very wisely, Mr. Water.
Been around enough, I think, long enough to know when it's sensible to push back and when it's not.
Yeah, okay.
So,
Keep
the
going.
next point is going to make a very short point about crypto being a third form of property which doesn't naturally fit within the moulds of shows as an action or shows as in possession. And I say, because we're dealing with an area of developing jurisprudence, questions of whether or not the rule applies, the market mitigation rule applies to crypto, is not one that should be determined on a summary basis. And obviously we rely on Begum and Moran for that proposition, the proposition that where you have an area of developing jurisprudence, it's generally inappropriate to determine matters summarily. In the interest of time, I'll just give you the reference, if I may. It's Authorities Bundle 29, page 1094, paragraphs 23 to 24. And similarly, if the rule does
which
apply...
was the page in the Authorities Bundle?
It's page 1091.
Thank you.
Paragraphs 23 to 24. And we set out...
I should say, while I'm... Sorry, I hadn't quite finished sounding off. I should say that the parties ought to know that I happen to be giving a lecture at the Old Bailey tonight about crypto assets. I don't think it's anything really to do with this, but it'll be well known that I do give lectures about this subject quite frequently. And I happen to be doing so tonight. I wouldn't want anybody in the court to think, or watching on the live stream, to think that the lecture has anything whatever to do with this case, because it doesn't. Or to think that the arguments in this case will affect what I say, because I've already written what I intend to say. But it may get published, it may not, I have no idea. Yeah. But I'm just, for the sake of the record, I wanted to say that.
Thank you.
I don't want anybody to be surprised.
So we say that even if the rule applies in principle, that begs the question of whether there is a substitute for BSV.
Yes.
Or an adequate substitute. That's the Stanford case, paragraph 43, which we cited in our skeleton. And that's clearly not suitable for summary judgment. And we say that there are a couple of authorities which have highlighted how difficult it is applying valuing crypto assets at any given point in time. And I'm going to draw your attention to the Phantom Foundation case, which is Authorities Bundle, tab 35, page 1309. First instance decision in Singapore. It was a decision handed down on the 8th of July, so after the hearing before the tribunal, which was on the 5th of June, but although before judgment. And there was a case involving misappropriation of crypto assets from a digital wallet rendered possible by breach of contract. You'll see that from paragraph 15 for your note, page 1318. Judgment was given in default because the case had received a great deal of publicity, and the value of FTM, which is the cryptocurrency in issue, was significantly affected by the judgment. The court provided detailed overture observations as to the assessment of damages in the crypto space, and you can get that from paragraph 4, page 1312. And from paragraph 35 onwards, the judge made a series of observations concerning the valuation conundrum of crypto, noting a series of issues that courts both in Singapore and around the world would have to grapple with. We can find that at page 1328. Under the heading Unique Nature of Cryptocurrency and the Valuation Conundrum. And he says, in considering what was just...
Whose judgment are we looking at?
This is a first instance judgment of Singapore.
Oh, whose judgment? Matter of interest?
Just remind, I've forgotten his name, I'll take you to the beginning. It is page 1309, 1310.
Mohammed
Faisal JC.
Faisal.
So can we go back to 1328, please? During this assessment process and considering what was just and equitable, I had to consider some additional issues related to the challenges of assessing the value of cryptocurrencies given their inherently volatile nature. And he, at paragraph 36, he identifies two issues. The second being how to determine the date of assessment of damages, or the reference point for computing the losses. His first point is a question that has to be considered at trial, but I want to pick up points he makes out the second issue. We can pick that up at paragraph 41, which you'll find on page 331. And he makes the point at 41 that the breach date rule doesn't apply where if there's no immediately available market for the acquisition of a substitute. And he's 3 lines in, he says, in such cases, as I had alluded to above, the assessment of damages is generally assessed by reference to the date of the breach, although it's but a general rule from which the court may depart if following it would give rise to injustice. And citing Hooper and Oates, the court in I-Venture noted the breach date rule doesn't apply in cases where there is no immediately available market for sale of the relevant asset or for the purchase of an equivalent asset.
I mean, all this does is make good the point I was making earlier. It should be open to you to argue that the breach date rule is varied by some weeks or months or days up until trial for various reasons which we may not know without evidence now. But beyond that, obviously not.
And can I just...
I see that he says also that paragraph 37, I think, that it can be a bit difficult to value cryptocurrencies because they might be traded on different exchanges and you don't just get one consistent price.
Yeah.
But it looks as if Mr. Noble has taken that into account at page 65 of his of the supplementary bundle that he referred us to, because he actually says that 53.6 million, which is the figure that he takes, I think, is the upper bound of the value held by UK sellers.
Yes.
And he recognises that might not be as high as that.
No, accept that. Can I take you on to 42 on page 1332, where he says, given the volatility of cryptocurrencies, the breach date rule may not always represent the best assessment methodology to value cryptocurrencies in all circumstances. And then at 43, over page, it's dealing with whether the court elects to assess the claim through the lens of a claimant's own loss. The court is still faced with the question of when to assess the quantum of loss caused by a breach. This becomes particularly relevant in the situation where the value of an asset increases or decreases dramatically after the date of breach, such as volatile assets are wont to do. And to illustrate, imagine a situation where a defendant misappropriates a Bitcoin at the end of 2018, when the price of one Bitcoin would be just under $4,000. The claimant files a suit a year later when the value is just north of 7,000, and by the time the matter comes up for trial, it may very well be another year later, by which time the Bitcoin would be worth just below 27,000. If the judgment date is end June 24, that same Bitcoin would be worth around 60,000. Valuing the quantum of loss at the date of a breach not only seems manifestly unfair, but it could also arguably fail to reflect the actual loss which the claimant suffered, or the loss which the claimant would be taken to have suffered if it had mitigated.
There are also incredibly complex issues about this being a class action.
Yes.
And, you know, to be fair to you and both sides here, it's got to be possible at trial to argue how the class action element of it applies.
Absolutely.
I mean, this is very interesting judgment by Judge Faisal, but he looks to be dealing with one person, one claim by one person. It's quite different from the class action.
Exactly, and he goes on to say at 44 that the reason the conundrum is so challenging is because the inherent volatility of the asset. Yeah. And he goes on, if you pick up the last sentence of 45 over page, well, the last sentence says, indeed, given the example, five lines at the bottom, given the example I gave above how Bitcoin has dramatically risen in price, it may be that even the approach undertaken in Diamond Fortress may result in an assessment that significantly underprices the loss, or in a case where the cryptocurrency crashes overnight, possibly significantly overstates the loss. The UK courts have not had occasion to consider the issue in the context of cryptocurrency. However, they have had the opportunity to consider the application of the breach date rule in general. On this matter, the UK's position is similar to Singapore's, in the breach date rule doesn't always apply to every case, albeit the UK courts appear to reject the notion that the breach date rule represents a general rule. Then he sets out Lord Legate's observations in the Stanford case that we've referred to in our skeleton argument. He says the error lies in the premise that loss caused by a breach of duty is generally to be assessed as at the date of breach. There is no such rule of law, which is really what this appeal is all about.
Well, unfortunately, I wish it were. I'm not sure it is.
Well,
what it's about is what you should be allowed to argue at trial, there having been a slightly ill-defined summary judgment application.
Yes.
That's what it's about. And it seems to me you probably should be allowed to argue anything within reason about which date the valuation should be taken, particularly in the context of a class action, but not to argue for some 300 times valuation, so as to put the defendant in a very difficult position with its accounts.
Yes. Can I take you to Southgate and Graham? I fully understand my Lord's position on this.
Yes, well, it's not a position, it's a current thought subject to Mr. Kennedy's argument.
Yes,
of course.
Of course.
Yeah.
So can I take you to Southgate and Graham, which is tab 34, page 1299.
I mean, one thing that is going through my mind is before you do, it follows from what my Lord has just said to you, is that, I mean, this is a collective procedure where in order to get certification, it has to be shown that it's suitable for the collective proceeding. I am struggling at the moment to understand how, if awareness of breach becomes a relevant or indeed important factor in the case.
Yeah.
That the collective procedure is going to how it's going to resolve it. What exactly are the questions? Or how did the CAT address that? Well, in a sense, it probably didn't need to, because it said on the view it took, it didn't arise.
I've been thinking about that, and I don't begin to understand how they can approach, if they have to decide if an issue of awareness is important, they have to decide that. I don't see how they can do it within the confines of class action.
For 75,000.
Exactly. I just don't understand how it can be sensibly done.
Well, it might be possible. I mean, there might be some.
But wait a minute, you're for the claimant, aren't you? So are you saying you shouldn't get certification?
No, I'm saying that awareness is not relevant, and therefore I say that's an issue that the CAT doesn't have to grapple with. Because I'm saying that you should be assessing loss as at date of trial, and therefore questions of when an individual...
Well, I mean, you keep on saying that, but where in your skeleton argument or anywhere else do you say the loss should be assessed at the date of trial?
Well,
I haven't seen that.
I'm saying it orally today in my submissions.
But you haven't said it before?
Not before today, no. It seems to be the logical position to take in the light of the questions I've been asked by this court.
Well, that's sort of being buffeted by the court, rather than actually having a coherent claim which is pleaded and in the skeleton argument and founding the appeal. I mean, of course you may be right, I have no idea, but it's again another aspect of the unsatisfactory nature of where we are.
Yes.
CAT say at paragraph 109 that they'll want to consider at an early stage how they're going to deal with the issue of awareness. Well, they don't say anything other than possibly a preliminary issue trial. I'm not entirely sure how that would work. But then they go on to certify it.
Yes.
There's no cross appeal saying they shouldn't have certified, but perhaps there might have been.
Yes. Can I just show you briefly Southgate and Graham, which is tab 34, page 1299. I've already briefly mentioned this. This is an appeal from the County Court decision to Mr. Justice Trower. The case concerned a failure to repay Ethereum tokens, referred to as ETH for short. The value of the ETH was valued at first instance as at the date of breach, i.e. the date where the debtor failed to repay. Such was the volatility of ETH. By the time of judgment, it was worth 10 times more than the breach date, and you get that on page 1302, paragraph 24.
Sorry, I'll ask the question when you finish. I'm sorry.
So paragraph 24, 1302, you'll see that 3 lines in, the volatility was such that it is worth approximately 10 times its value as at the valuation date, but by the time of the judgment it was 10 times the valuation date picked by the judge. And then at 1305, paragraph 50, he highlights the fact that whilst the market mitigation rule is a general rule in contract cases, even then it's not to be rigidly applied. And then at 54, he highlights the unfairness that would potentially bring in that case, because it would mean that with the damages, the creditor would only be able to go out and buy a fraction of the tokens, and that's on page 1306, paragraph 54. And he went on to say at 1306, paragraph 57, that the case was more akin, therefore open to the creditor to argue he'd already provided full consideration in the form of the original transfer, and the nature of the oral agreement is therefore closer in its essence to a contract of loan than it is to a contract of sale. In that context, and depending on the evidence adduced at the remedies hearing, it may be more credible for the creditor to contend that he is under no obligation, or in any event a more limited obligation, to go out of the market to make a substitute contract, where he would in fact be paying twice if he were to do so. And then he goes on, as I've already shown you, paragraph 58, to quote from McGregor, and I've already shown you paragraph 61 to the effect that where the innocent party has already performed his side of the bargain, the question of what the innocent party could and should have done once the breach became clear becomes a factual inquiry. And we say the problems that we've identified become compounding when considering that this is a class action case. And we say the rules of mitigation in the context of competition class actions are yet to be fully mapped out. And if the market mitigation was held to apply without any further inquiry in respect to 75 investors, that would mean from the date upon which they became aware of the delisting, each of the 75,000 would have had to sell their crypto. Now, I know I've taken up quite a lot of time this morning. I did want to spend some time dealing with the question whether there was an available substitute. Because if there wasn't an available substitute, then the market mitigation rule does not apply. So,
can I just ask the question that I was going to ask now before you do, because it may be relevant to that. As I understand the answer you gave to the Master Rolls a few minutes ago, you're saying that actually the logic of your position is that you want to argue for the date of trial as being the date of assessment of loss.
yes.
What happens if to people who sold their BSV coins in subclass B on the 30th of July and bought Bitcoin? How do you deal with
But
it?
then they would have to be dealt with as they'd have to be put into subclass A. They would have to
Well,
be
they're
dealt
not. But they're not, because just looking at the way the classes are defined, I don't understand. The classes don't seem to cater at all for anybody who sold their BSV coins, sorry, their BSV after the 29th of July. There just doesn't seem to be any, unless I've missed it somewhere. How is any of that catered for on your, when you're now saying you want to be assessing damages?
Well, when I said that, I was assuming that the classes remained unchanged and that the Class B holders still hold.
Well, but that's not what their Class Bs were about. The Class Bs just say they continue to hold at midnight on the 29th of July 2022 when the claim was issued. But suppose they sold their BSV the day afterwards and bought Bitcoin.
Well,
How does the formulation of the classes even begin to grapple with your contention that the foregone loss, etc., whatever it's called, should be assessed as at the date of a trial without any other factor being taken into account?
it may not be a satisfactory answer, but Mr. Noble's report just doesn't grapple with, or what happens if someone in Class B subsequently sells, and the claim doesn't grapple with it.
Because, I mean, if you were dealing with date of breach, then of course the problem doesn't arise.
I get that.
And that seems to have been the basis on which this has been approached. But you're now saying, no, it's all to do, we want to argue date of trial. But I just don't understand how the composition of the classes you put forward for certification even begins to deal with that. This has nothing to do with awareness of breach.
No, but can I think about that over the shorter journey?
Yeah.
So dealing with this question of substitution, the tribunal's approach effectively assumes a two-stage process. First, the one's able to sell the BSV, and second, the acquisition, one's able to acquire a substitute cryptocurrency. And I've already made the point that if the required mitigating act of the 75,000 members in Class B is that they all should sell. It may be that they don't get any money for their BSV, or only get a very small amount, and therefore can't buy a substitute, even if a substitute is available. But looking at the acquisition market to ask the question whether or not a substitute is available, it's got to be an adequate substitute or equivalent substitute. However, we say it's a massive oversimplification to say that, as the respondent says, that the question is one of whether the asset would have had the same or similar prospect of an upturn in value. And even then, one is entitled to ask rhetorically, how do we assess at this stage the prospects of an upturn in value for BSV as compared with other cryptocurrencies? And by the same token, what weight is to be attached to the fact that BSV is a contender currency as compared with more established currencies like Bitcoin or Bitcoin Cash? And we don't go so far to say that there was no substitute. We just say it's inappropriate to decide at this stage on the basis of Mr. Noble's first report that there was a substitute. And the real reason, there are really two fundamental reasons. First of all, Mr. Noble wasn't considering substitutability. He was looking at comparators with a view to assessing loss. And secondly, he made it absolutely plain that his views were provisional only. And the starting point is paragraph 212 of his first report, which you find in the supplemental bundle at tab 18.
Well, it may be that now is not the time to go to that. We'll resume at